We have motions regarding custody, issues regarding harassment, return of clothing, requesting that the court speak with the child, and there's a show cause and a request for contempt. Ms. Oswald's in the courtroom. She's in pro se. Mark Page II appears via the Zoom application. Will both parties please raise your right hands?
The testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Yes, ma'am.
All right, before we proceed in this matter, didn't we have a hearing not too long ago regarding an issue with Mr. Page and that I believe a fine was assessed?
Yes, Your Honor. On December 13th of 2024, the court held the show cause hearing. The order after show cause entered on December 19th, and a $100 sanction was assessed by the court, which was due and payable to the Friends of the Court office by January 3rd of 2025. Our records indicate that sanction remains unpaid as of today.
All right. Mr. Page, have you paid that fine?
I have not been able to. I've been out of the job, sir. I've barely been able to survive, honestly. Like, I've been working on trying to get things together. I've been working on trying to get myself together. I've been trying to get my own place. Like, me and the mother of my son are no longer together. Like, yeah. I'm just going through a lot right now, Your Honor. Dealing with this whole situation in this house.
How are you supporting yourself right now?
Doing side jobs.
Okay, so out of those side jobs, you can't scrape up $100 on a court-ordered obligation?
I understand that, but like I have to take care of, like, I've been trying to take care of everything else that I'm trying to get, like trying to find a place to stay, keep my car running so I can get to work if I do get a job, like all types of other things. Like my phone was off almost half the month last month because I couldn't find any way to phone bill.
Okay, I'm having
That's how
issues
struggling dealing with this situation that I've been dealing with since Oswald, sir.
Okay, I'm having kind of a difficult time hearing you. I think I understand it. We'll have to address it here in a moment. Well, I'm going to address it right now. You are able to work though, correct?
Yes, I'm able to work. I've been trying to find me a job. This, like, sir, like that's what I've pretty much been doing for the last month and a half.
I'm sorry, I didn't understand you.
I say, yes, sir, I am able to work, and I've been trying to find a job for the last month and a half.
Okay, where have you applied?
I've applied to fast food restaurants. I've applied to Ford multiple times. I've even applied to like trying to do DoorDash and Uber Eats and all that. Like, I've been trying to do all of that. I've been applying. Like, everywhere I see a now help wanted sign or a now hiring sign, I've applied to. I've literally got multiple applications on Indeed that I've put in. Like, I've been trying to put in for application after application after application.
All right, so DoorDash requires you to operate a motor vehicle, correct?
Yes, sir.
Okay, when did you apply at DoorDash?
I've applied at DoorDash on multiple occasions, but the fact that I'm not able to afford insurance, they won't accept me. But I keep applying in hopes that I can get accepted.
All right, so sounds like you have an operational motor vehicle.
Yes, sir.
Okay, because I mean, you wouldn't apply. You would not apply had you not had an operating motor vehicle. All right. Well, the court speaks through its orders. If the obligation is due January 3rd, 2025, it's required to be paid June 3rd, January 3rd, that is, 2025. You stated that you do have side jobs and that you have other bills and obligations, but this potentially is your freedom as well, because the court could hold you in contempt for failing to pay the fine based upon a previous sanction that was ordered. Court could potentially impose jail time. You want the court to do that?
There's no need to do that.
There's no need. You didn't pay.
I understand I didn't pay. I didn't have the funds to pay, sir. I can't pay if I don't have the funds to pay, sir.
Well, you're paying your other bills. This is an important bill as well. When can you pay the $100?
I can have the $100 to you next week.
I'm
I
sorry?
got a couple of sides. I can have the $100 to you next week, sir. What's today's date? The 14th?
Yes, sir.
Gonna check my calendar. Give me one moment.
Next week would be March 21st.
I can have it paid by Friday.
By when?
Next Friday, the 21st.
Okay, March 21 by 4:30 PM. If it is not
Okay, sir.
paid, if it's not paid by March 14 or 21, that is, by 4:30, should we just, I mean, is there any sense of setting another show cause, or should the court, what's the recommendation of the friend of the court on this? Is the payer stay type of situation? He's able to work.
I will defer to the court on that matter, Your Honor. In the event that it's not paid by next Friday, the friend of the court can request it as well.
Okay, we'll do it that way. So if it's not paid
What did she
by
say?
March
Hear what she said?
21, she just made a recommendation regarding what can happen in the event you don't pay. So if you don't pay at the close of business, March 21, they will renotice it, and I will require you to appear in person to the Huron County Circuit Court. And then we can address it at that time. So that addresses that. Want to deal with the show cause next, Ms. Schultz? Or Mr. Holway?
Your Honor, the friend of the court did not file a show cause. Ms. Oswald filed her own.
Oh, I'm sorry. Okay. Ms. Oswald, you are under oath. What is the issue? I believe it's denied parenting time on February 16th.
Yes, sir. So it was during that really bad snowstorm we had gotten. I had left the house at 3 o'clock to make sure that I made it to Imlay City on time. And I did not receive communications from Mr. Page until shortly after 4. I had already driven through Marlette. By the time I had gotten to Imlay City, I had been told by Mr. Page that he didn't have the finances to bring our daughter to Imlay City. And I let him know, well, you said that you get paid tomorrow. I can drive down tonight. I will meet you in Canton Walmart on Belleville Road and Michigan Ave. I will call you 20 minutes before I get there so that I can pick her up. When I got 20 minutes away, I shot him a message on the app and I told him, hey, I'm about 20 minutes away. I'll see you when you get there. It was roughly at least 45 minutes to almost an hour until I got communication back from him stating that he was not going to meet me at the Walmart, that he refused to give her to me until the following day, which was a Monday, not Sunday. And then he sent me a picture that he did then at that point in time have the supposed finances to transport her, but I had already made the trip down. I was literally sitting at the Canton Walmart. I let him know that if he wasn't going to return her to me, I was going to contact the Canton police. You can see from the police report, that is exactly what I did. The first deputy I called at the dispatch, I had contacted them and they said to move from the Walmart parking lot where I had been waiting to the entrance of his son's mother's apartment and contact them again. Because his mother's address is not where he's at. That is not where he's had baby girl the entire time she's been down there. She has been at the address located on the police report. It wasn't even the person's name that you and I were even given. So I did exactly as the police told me to. I parked directly inside of the entrance in one of the parking lots right at the entrance. 2 police officers showed up in the first vehicle, a female and a male, and then a male officer showed up in the second vehicle when I had left to go to the gas station to use the restroom. By the time I came back, all 3 officers were there. The female officer asked me to follow them to, I don't know how to pronounce his son's mother's last name. But I was requested to follow them to that address to see if Mr. Page would return her to me at that time. I had shown the police officers the court orders from you guys about the midwinter break and the denied returning of her. The officers said that they could not take her from him and to file a report and bring it to you.
Okay, so you missed one day on top of that.
I missed all of Sunday. I drove down there. I blew $35 in gas just getting down there and back to Imlay City, when he could have easily just given her to me and it would have just been done and over with. I wouldn't have fussed. I wouldn't even have been coming here.
Okay, thank you. According to the front of the court records, mother's entitled to Sunday evening, correct?
Yes, the parenting time order grants Mr. Page parenting time every weekend, Friday at 6 until Sunday at 6. The parties do have alternate holidays for the 2022 guidelines, but my understanding is that the school district does not practice an official midwinter break.
Nice. Thank you. Mr. Page, do you have a response to all of this?
I was under the impression that with her midwinter break, I got her before she went back to school. So that's what the impression I was under, because year before when Miss Oswald did it, I didn't get to see my daughter at all for her midwinter break because of this whole situation of it falling on a weekend.
Okay, so do you acknowledge getting messages from Ms. Oswald regarding pickup and drop off that day?
And I also like Miss Oswald told you, I did let her know that I did not have the funds to bring my daughter. She wanted to chill with me another night, and that I would bring her Monday morning for her. But no, Miss Oswald decided to not try to work with me on any of it because I didn't have the funds at the time. She didn't hear from me because I was in the process of doing some work to try to make money so I could have the funds to bring my daughter back to her like I was supposed to.
Okay. Any other explanation?
No, sir.
Okay. Based upon the information presented, the court finds that there was no justification on behalf of Mr. Page. Ms. Oswald had even gone as far as to travel down to the location to pick up the child pursuant to the order. As a result, I find Mr. Page in contempt for failing to turn over the child as required under the court order. Mr. Page, is there anything you'd like to say before the court imposes disposition?
I don't understand why I'm being held in contempt for my daughter's wants. But I understand what you're saying. So I understand
Okay,
it's the law, but it was what my daughter wanted at the time. And I understand that it's like, she also said that she did not want to go back with her mom that night. So, but I understand it's the law and that's how the law works. But that doesn't sound like it's in the best interest of the child for me with the way the law works. So I'm just letting you know my opinion on it, sir.
Sure,
but I understand.
I appreciate that. But if there's an issue regarding the best interest of the child, obviously you can file a motion to that extent. As a result, the court also finds bad faith on behalf of the father. Mother attempted to try and pick up the child pursuant to the order, even though the child may have said, and it's hearsay regardless, that she may want to stay additional day. The child doesn't call the shots. The parents call the shots based upon the court order. As a result, the court is going to impose a $250 fine to father. That will be due and payable within 30 days from today, which would be, we'll make it April 14, 2025, $250. Court is also imposing an additional sanction of $35 for additional expenses that mother had to incur in traveling down to the Canton area to pick up the child following the court order. Again, all of that will be due, the $250 plus the $35 on April 14, 2025.
That's
Now,
crazy.
sir, do you want another contempt citation based upon that last statement?
No, sir. I'm not talking about anything you said. I'm just thinking about how Ms. Oswald is literally manipulating the court system to get her way. That's the only thing that I said that for. My apologies, sir.
Well, I don't accept that. I may accept your apology, but I don't accept that that's crazy based upon what Ms. Oswald did is based upon what the court ruled, as far as I'm concerned. Don't engage in that
No, I understand
behavior
that.
again, because I don't want to hold you in contempt. And please place the camera where we can see you, sir.
I had my phone up to my ear so I could hear you guys. My apologies.
Okay, I'll accept that. I'll accept that. That's fine. Now, we also have motions regarding custody, harassment, returning of clothes, wishing the court to speak to the child. Let's address those now, Ms. Oswald.
As far as the clothing goes, I can honestly say I have finally gotten all of the clothing items. But my disgruntledness over that. Can I give this to y'all? Because this is how they were returned to me. Holier than holy crap. And I apologize for my language, but it looks like somebody cut her gotchis. She's got a hole in her pants and over 6 holes in her favorite sweater. And he's had told me in the court-appointed act that I sent her to him like this. Like
That's how those clothes were sent down to me. Before they were returned to Miss Oswald, they sat in a grocery bag until I was able to get back to the mother of my son's house to get her clothes for my daughter. You can guarantee that I have nothing to do with those holes in my daughter's clothes. Her dog, who's untrained, also likes to chew on everything of my daughter's, because every time I pick my daughter up, something new of hers has been chewed up by her untrained dog.
Do you have firsthand knowledge of that, Mr. Page? I mean, have
Yes,
you
sir,
seen
I
the dog?
do. Yes, sir, I have, because before me and Miss Oswald were no longer together, that very same dog was in our possession, and it chewed up everything of my child's. Every chance it got.
When was the last time you were together?
This was over 2 years ago, sir.
2023.
Over 2 years ago. Okay. What friend of the court policy, just to let the parties know regarding clothing.
Each party is responsible to provide the child with whatever she may need during their respective periods of parenting time. There is no requirement that materials be exchanged that belong to the child.
This was the outfit that baby girl wore down there. He sent her home in an outfit that he had purchased.
Was that clothing in good shape?
The clothing that he had sent her back up to me in was in good shape. I washed it, I dried it, I sent it back down in a bag in perfect condition.
Okay. Okay. We'll address that in a minute. What are the allegations regarding harassment?
You had requested that his son's mother leave me be. She had no right nor reason to speak to me at pickup, drop off, or through text messages. If you look at the paperwork connected to everything that was sent into the courts, you will find more text messages from this other person, because I don't know what her government name is anymore. I don't know who she is, honestly. And she literally sat in his car twice and screamed that I was a stalker because I gave the police officers the information that my daughter had given to me in chance that she was not returned to me. This way I could find her. And I would very much like you to talk to my daughter about all of this yourself so that you can get the full story from the little goose herself.
Is this Mr. Page's mother?
She'll also tell you
No,
how
that
her
is
mother
his son's
harasses
mother
her and
that
interrogates her
was
to get the
Oh,
answer.
just a moment, Mr. Page, just a moment. I'm speaking to Ms. Oswald. So who is this individual again?
You knew her by Ashley Smith. That would be his son's mother.
Is this a former significant other or current significant other of Mr. Page?
He had stated when he first came in that they are no longer together.
Okay. Mr. Page, what is the individual's name that Ms. Oswald's referring to?
Her government name is April Snow.
Can you spell the first and last name, please?
April as in April.
Okay.
I'd also like to add, Judge, that I'd love for you to talk to my daughter on how her mom literally makes her cry to get answers from her because Miss Oswald literally interrogates her like a prisoner, and how she also feels about this whole situation of what her mom is doing just because I don't want to be involved with Miss Oswald anymore.
Okay, well,
My daughter will tell you the entire truth.
excuse me, Mr. Page, I have to interrupt both you and Ms. Oswald. When it comes to what the child may have said to each of you, for the court to consider is hearsay. So the court cannot consider that. However, regarding Ms. Snowdy, didn't I order her off limits before?
Yes, you did. At the last time that we spoke back in December, you had told me and him, because you also had a problem with her speaking while he was on camera, that she didn't need to have any type of communication or even speak in any way, shape, or form, that she didn't need to talk to me during pickup drop-off. She didn't need to contact me through text messaging. She wasn't supposed to contact me.
Okay, so on the date in question when you went down to Canton to pick up the child, April Snowdy was there?
She was at the apartment that night. I did not see her nor speak to her that evening, but the next day when Mr. Page finally met me at 6 p.m. in Emily City on Monday, President's Day, is when she started screaming across the parking lot about a car or two away, about how I'm a stalker.
Okay, I've heard enough on the issue. I am going to order, if I haven't ordered already, that at any pickup or drop off, Ms. Snowdy is not to be there, period. Mr. Page can exchange the child with Ms. Oswald. There's no need for Ms. Snowdy to be there. I'm ordering that. In the event that Ms. Snowdy is there, and it can be proven, we can have a show cause hearing, and Mr. Page can be brought to task on that if it happens. Now, regarding the motion for custody, I read your motion. Is there anything else you wish to add?
I'm really just looking to get things changed, at least temporarily, until he's able to at least put forward into child support, because it costs me roughly about $230 to $275 a month in transportation and feeding her every Friday and every Sunday evening.
Okay. Mr. Page, any response to the motion for custody, sir?
No, I'd rather it stay the same because it costs me almost around the same just to be able to drive up there and back.
Okay.
And to take care of my daughter as well. So I mean, there shouldn't really even be a difference. It's because before we even got this far into the court system, when I came up there when it first all happened, I was told 50-50, not every weekend. Last time I checked, every weekend isn't 50-50. And the way she did her whole situation was uncalled for in the first place. Like I was unknowingly, I found out through my child that they even moved up there overnight after Miss Oswald had told me, and I have proof of the messages that she wasn't going to run away to her parents' house to keep my daughter away from me.
Mr. Page, I'm sorry, I have to interrupt you. We're kind of going off the beaten path here. We're kind of talking about the old stuff here. We're talking right now about the current motion. The court has reviewed the motion for custody in this case. There must be either proper cause or change in circumstance in warranting a review of the custody factors. Based upon what the court has heard, clearly this is a battle between Ms. Oswald and Mr. Page regarding not only communication, but how they interact with the child, etc. And after reading the motion and hearing the respective argument from Ms. Oswald, court does not find a change in circumstance or proper cause. So unfortunately, respectfully, I have to deny your motion for custody. However, what I'm going to order in this case moving forward, if there are any future motions or any future show cause hearings of any party, both parties must appear in person. I will no longer allow Zoom for any party in this case. It's difficult to be able to hear and understand the statements of Mr. Page because of the connection. And as a result, I will require this point moving forward that parties must appear in the courtroom in person. Prior orders will remain in effect. I also order that there is 1 day of makeup time that needs to be done within 6 months of today's date for the Sunday that was denied. And is there anything the court is missing, Ms. Schultz?
Clarification on the contempt sanctions, Your Honor. The $250 sanction due by April 14th that is payable to the friend of the court office.
That is correct.
The $35 sanction due the same date, is that also payable to the friend of the court, or is that being reimbursed to the plaintiff?
What would be easier, because the parties don't communicate very well? What do you recommend?
If that sanction is paid in cash or money order payable to Ms. Oswald, friend of the court can facilitate that.
So it'd be payable to the friend of the
But
court.
we cannot deposit it into our.
Okay.
account and cut-
So if it's cash or money order, Mr. Page, regarding the $35, the friend of the court can help you regarding that. If it's any other method that it has to be placed in the friend of the court account, that won't work. You understand that?
Okay. I understand, and I also have no issues. The last two drop-offs, we've had no issues. Like I said, me and my son's mother are no longer together, and every time I've attempted to communicate with Ms. Oswald, she's made it difficult. So I understand what you're saying. So I'll gladly give it to the friend of the court.
Well, I'm not going to go into anything else moving forward, other than the parties need to be able to work together. That's all I'm going to say. So that's how we'll proceed. You're all set.
I have one quick question.
Go ahead with your question.
Is there any way for you to talk to our daughter about everything that has been going on? Because she has personally requested me to ask you if she could speak with you again about everything.
Well, I've denied the motion for custody. If there's a subsequent issue that comes up down the road, another motion for custody or parenting time, certainly the court can entertain that at that time.
Okay,
Because I've denied the motion, I can't allow that.
totally understandable.
All right, thank you. That'll be all. You're all set with your page. Have a great day.
Thank you.